So now it's a constitutional amendment in Arizona and also a constitutional amendment in Oklahoma. Actually, thank you. So what had started out as, like I say, unintended consequences, the original intention of this bill was for just local politics, but the advent of the 2008 election suddenly made the kind of the ancillary aspect of it, which was it's probably a good defense against national health care reform. That's what suddenly made it attractive to everyone and got a lot of support behind it, got a lot of momentum behind it. So meanwhile, it passed in Arizona. Since 2011, North Dakota passed it as a statute, Tennessee passed it as a statute, and I'm happy to tell you just at the end of the day yesterday, the Kansas Senate passed it. It's gone to the Governor Brownback's desk, and it will be, he's going to sign that. So that'll be 9 states that have Health Care Freedom Acts as a statute and 2 that have it in their constitution. Now, sad to say, North Carolina's legislature passed it as a statute, but their Democratic governor vetoed it a couple of months ago. It's on the ballots in Florida and Wyoming for 2012, and it's very likely to be on an Ohio ballot this November 2011. Now, here's the other unintended consequence. Our entire plan was that if this gets, we wanted to be able to say to the Supreme Court that our Constitution protects a person's right to choose or not to choose to participate in any particular health care system and to make their own personal arrangements for how they're going to get their health care. Everybody has a copy of the amendment in front of them. And every state that's passed it is pretty much, with minor changes, passed the same exact language. So our defense is twofold. Number one, like I pointed out, this sort of 10th Amendment argument that the police power of the states pertains to health care, and if this is our constitutional or even statutory law, then the state takes precedence over federal. There's also a 9th Amendment argument. I don't want to get too arcane here, but those of us in this room who study the Constitution know the 9th Amendment to the U.S. Constitution says the failure to enumerate certain rights should not be misconstrued as to deny or disparage the rights retained by the people, which means just because we didn't mention certain rights in the preceding paragraphs doesn't mean that there aren't many other rights that the people that reside with the people inalienably. Of course, that's always presented a problem legally because since they weren't enumerated, you can get into big arguments over what is and what isn't a right. So an argument can also be made, well, clearly one of those unenumerated rights is the right to make your own choices about health care because several states have chosen to protect that unenumerated right in their constitutions. So that's going to be another argument. So that was the intentional use of the Health Care Freedom Act on the national level. But here again go the unintended consequences. Before we even had our election in 2010, the governor of Virginia, using his state's now passed Health Care Freedom Act, as you know, sued the federal government on the grounds that the individual mandate is unconstitutional. And one of the arguments that the opposing side put forth is, well, you don't have standing to sue on the grounds of the individual mandate. It doesn't even take effect until 2014. So what are you bringing this up for right now? Number one. Number two, what is this? Is this in the state's business? So the governor of Virginia said, well, actually, we have a statute saying that a person can't be forced to participate in a health system if they don't want to. So we do have standing because you just passed a law compelling our citizens to participate in a health system. That argument gave them standing and allowed them to go forth and, of course, win on a district level. I'm not optimistic on the appeals court level, but it'll go to the Supreme Court. Meanwhile, Florida filed suit on individual mandate and on, they also had a complaint regarding 10th Amendment issues, which is that Obamacare is forcing states to spend more money on Medicaid, and that's usurping the legislative authority of state legislatures. Well, they were going to have a problem having standing to file their suit because they don't have any statute. They haven't yet passed the health. Actually, their legislature referred it to the ballot, but their Supreme Court threw it off on a technicality, so that's why it's now on for the next election. Fortunately, they were joined by 25 other states, including Arizona, Oklahoma, Idaho, Georgia, Louisiana, Utah, Missouri, and not Virginia because they have their own suit. So the court said, well, many of your co-plaintiffs have standing, so we're going to let this case go forward. So another unintended consequence of the Healthcare Freedom Act that we didn't kind of notice, but it's obviously it's a benefit, it's worked to our advantage, is that it's given states standing when they want to challenge Obamacare and eliminates that argument. So now we wait to see, how it goes to the Supreme Court. Meanwhile, in Arizona, not only did Arizona join that suit in Florida, but the Goldwater Institute filed suit, and we're waiting, actually, hopefully next month, Judge Snow of our district court in Phoenix will hear the case, and we're optimistic. Judge Snow is a George Bush appointee. So far, it seems it's all political, whichever president appointed which judge. But of course, we're with you in the Ninth Circuit, unfortunately. So we know the appeals court will probably overturn our district court decision, and then we'll go to the Supreme Court. But now, we have a different case. Our case is two things. First of all, we're the only case to our knowledge that has noticed this. As soon as Obamacare passed, the legal team at the Goldwater Institute started pouring over, looking for something that other people haven't already found because we don't want to be redundant. And we found a very good reason to challenge Obamacare on the IPAB, the Independent Payment Advisory Board, which of course takes effect in 2014. It's 15 presidential appointees who will decide what will be covered, what won't, what reimbursement rates will be, what they won't be, et cetera, et cetera. In other words, a death panel. And to make it so it's not subject to political pressure, in the legislation it says that any decision that this IPAB makes can only be overturned by a 2/3 majority in each House of Congress, that any decision it makes is not subject to judicial review, and that after 2017, the IPAB can never be repealed. Now, I just told you 3 things that are unconstitutional. And the Goldwater Institute is apparently young people have noticed this. So that's one. So the plaintiffs in our suit are Congressman John Shadegg, he's just retired, who's now a fellow at the Goldwater Institute, Congressman John Shadegg, Congressman Jeff Flake, and Congressman Trent Franks from Arizona, are plaintiffs arguing that you cannot, this Congress cannot compel a future Congress as to 2/3 vote, whatever. That's up to each Congress to decide the rules when they have a vote. So it's unconstitutional. Number 2, you can't pass a law that's not subject to judicial review. That's a violation of the separation of powers doctrine. And number 3, you can't pass a law that you can't repeal. So that's one part of our suit. The other plaintiff to our suit is Nick Coons, who's a small businessman in Tempe, Arizona, who is self-insured, meaning that he just has enough money saved. He pays for his own health care privately. He would like maybe one day to consider buying a very high deductible catastrophic policy when he has a family. But of course, Obamacare forces him to buy health insurance and will actually bar him from having that kind of high deductible catastrophic policy available to him when he would want it. So he is a plaintiff saying the individual mandate is unconstitutional because Arizona protects his right to not have to play in this game. And we, of course, cite these arguments that we originally intended to use. Interestingly, the feds have already responded to our complaint, and they took on the Arizona Healthcare Freedom Act, saying that it is that is not allowed because the Supremacy Clause of the U.S. Constitution gives federal law precedence over our state constitutional. That's exactly what we wanted because we wanted to have this discussion. So the only thing that's unfortunate is that we're sort of late in this thing. By the time our thing makes it up to the Supreme Court, it'll probably be 2013. By that time, we would hope the Supreme Court will already have decided on the Florida and Virginia cases and maybe a couple of others that have been consolidated. So if the Supreme Court overturns Obamacare, then our case becomes moot. That's a nice problem to have. We'll remove our case. If they find parts of it unconstitutional and parts of it not unconstitutional, then we come along as a second wave. But in the meantime, the Healthcare Freedom Acts seem to be a really effective means of, on the state level, in those states where you can pass it as a proposition, or other states where you can work on your legislature to try to pass it as a statute, where you could mount a resistance through the courts to Obamacare. I was asked to comment on whether or not I think that's possible in California. I do not think it's possible in California. With this legislature, this governor, I can't see the legislature passing anything and referring it to the voters, and it's just such an expensive state to try to get petitions signed. So I guess you'll just have to leave that to the rest of us. Thank you.